Great, thanks so much, Jay. And welcome to the webinar, everyone. Please make sure to let us know if you are having any problems hearing things or volume or anything. I want to just acknowledge we are using some new software, and so hopefully we've got all the bugs ironed out, but if not, we really want to hear from you to make sure that you can benefit from the information we're going to share today. So with that, we're going to just briefly go over what we're going to be covering today in the webinar. And as Jay mentioned, we're going to be talking about the current revisions and proposed revisions to Minnesota's food code. And I think to really be able to understand those revisions to the food code, it's important to understand the background and legal structure of Minnesota's food code, to then be able to navigate and understand what the potential areas of impact on healthy food and hunger relief efforts are from the proposed food code revisions. And then also something that we've been hearing a number of questions about is whether and how people can navigate the process for the current food code revisions and what possible opportunities there could be moving forward. So we're going to be going over those things today. And again, we do invite any questions along the way. So today, again, my name is Marrow, and I'm a senior staff attorney at the Public Health Law Center. I'm going to be moderating today's session, and also I'm here with Amanda Karls, who's another staff attorney at the Public Health Law Center. And I just wanted to acknowledge that we're going to be trying a slightly more informal approach to today's discussion. And so Amanda and I are going to be having a little bit of a back and forth here as we're discussing some of the proposed food code amendments and how we understand it may interplay with some of the activities that are happening out in Minnesota based on the work that we've done here at the Public Health Law Center with SHIP grantees, other local community advocates, and others who are really invested in improving the health of our community. And also, I think as we're getting started, I just want to recognize the complexity of the food code, and we're going to, give it our best shot, and also acknowledge that hopefully we don't know just enough to be dangerous. I think that we do, understand a number of things, and I can definitely attest that Amanda and we've been spending some time really trying to digest some of the proposed rule amendments, and have had numerous conversations over the past few weeks and years with some of the administrative agency staff who have been involved in developing the revisions. And there's a lot that is in the details. And so we're going to be providing a snapshot of some different things. And it is not at all the end all be all. We aren't the authorities here. And so we just wanted to flag that with a caveat that this is an introduction to some of the things, but there are going to be a lot of opportunities even later this week for you to learn more about the proposed regulations. So just to get started, I don't know if all of you are familiar with the Public Health Law Center, but we are a public health policy institute located at Mitchell-Hamlin School of Law, and we focus on supporting community, state, and national efforts to address public health issues facing the United States and our local communities at all scales. And one of the key areas, as you all know, I would assume being on this webinar, is that access to healthy food and some of the chronic health issues that we are experiencing, from obesity, diabetes, cardiovascular issues. A lot of these things are really tied to lifestyle issues. And one of the challenges is that many of our laws and policies were not designed to deal with the long-term impacts of our lifestyle, but were more focused on the immediate needs of ensuring sanitation and access to, as we're going to be talking today, access to safe food, avoiding foodborne illness, all of those things. But I think that we've learned as a community that there are a lot of other policy and legal implications to our health that are longer term that we're just starting to see. And so at the Public Health Law Center, we really work to support your efforts in the community. And this webinar in particular is being supported by Blue Cross Blue Shield Center for Prevention, and on behalf of their grantees and the work across the state in understanding how the food code revisions can impact access to healthy food in Minnesota. Also, I just want to acknowledge that what role the Public Health Law Center plays. We conduct legal research, help to develop policies, help people understand how to effectively implement policies, and also can provide some legal defense for some policy efforts. We develop publications in response to work in the community and different trainings we conduct, including this type of a webinar. However, we do not have any direct representation, so we don't represent people as in an attorney-client privilege situation, and we don't lobby. And I really want to just focus on the lobbying piece just for a minute, because we don't lobby, we are not in a position to really make recommendations or suggestions about specific parts of the food code. We can identify different areas of interest that could possibly impact food access at the local and state level, and it's really up to you on the ground to assess how that could impact your work, and as part of some of the bigger conversations that we're having. So to get us started, I want to take us back to some conversations that I know I've had with around the state in the past 2 to 3 years around this idea that there's kind of 2 different components to the food conversation, and both of them impact our health, but in different ways. And so there's the conversation about healthy food and safe food. And I think that there's a lot of awareness about the impact of access to healthy food, nutritious food, on our chronic health considerations, like I was talking about, diabetes, heart disease, and other things that are more lifestyle based. But one of the things that is important to keep in mind is that those chronic health issues and that long-term perspective is only relevant if we also are managing our immediate need for having safe food as well. And safe food is the idea that we want to prevent foodborne illness and other kinds of acute illnesses from pathogens and other hazards. And so there's a push and pull over the years and in conversations about how to navigate this relationship between healthy food and safe food, and recognizing that a lot of our food law in particular has been organized and structured in response to the need for safe food. And we're really grappling as a community, as government agencies, as public health advocates, about how do we bring the healthy food piece into the conversation. So there have been a lot of efforts at the University of Minnesota Extension, Department of Health, a number of efforts through the Minnesota Food Charter in talking about how to elevate healthy food along with the safe food conversation. And this is a snapshot that shows kind of the continuum of, or the range of how the relationship between healthy food and safe food can play out, from the things like spinach or cilantro or bean sprouts, things that are very, very healthy and nutritious, but have a much higher risk of being a vehicle for foodborne illnesses than, say, if we're looking at the far right corner, lower right corner of this chart, showing less healthy foods that are safe foods, which we can think about potato chips and frozen pizza and some things that are very safe from a foodborne illness perspective, but very unhealthy from the perspective of our long-term health outcomes. And we're just gonna, sorry, we're having a little bit of a lag with our technology, but one of the things that I wanted to move on to is just talking about what is the purpose of the Minnesota Food Code. And ultimately, the Minnesota Food Code was designed to protect consumers of retail food and food service by preventing foodborne illness. So by preventing some of those things in the upper left-hand corner of this visual, as opposed to dealing with the health implications of eating more processed and safer foods. And foodborne illness or injury is something that is specifically defined by law, and it covers ingesting food contaminated by bacteria, viruses, parasites, or other natural or human-made chemicals or other foreign or hazardous objects. And so that really is largely what the focus of the food code is. And for this and I wanted to just address that we have been having this conversation with you. And I want to remind you about a webinar that's available on our website from October of 2016 that we developed and produced along with people from the Department of Ag and Health, talking about some of the anticipated changes with the food code that we're going to be talking about a little bit more specifically today, and also some of that tension about how can we navigate and move beyond just safe food to include the health and nutrition of our food as well. And so then the question is, why is the Minnesota food code being updated? And I wanted to just draw your attention to this very informative and yet a bit lengthy document called the Statement of Need and Reasonableness. And it's also called the SONAR, just for short. And I think that Amanda and I will be talking about the SONAR some as we start talking about some more specific issues. And this is a really valuable resource, and it's something that's been put together by the agencies, by MDA and MDH, to help explain some of the justification and the reasoning behind some of the proposed changes for the food code. And also it talks about why the food code is being updated specifically. And I found this really helpful to just provide some context. And so, as the SONAR indicates, the Minnesota's food code was first adopted in 1998 and really hasn't gone through any major revision since then. So that's a 20-year period when our food code rules, things governing food safety and food retail, there have been a lot of changes in the past 20 years. There's a lot of things that we understand now that we didn't understand 20 years ago. Technology has changed. I mean, just things like the internet and so many things have changed during that time. And we, in Minnesota, our food code hasn't kept up with those changes. And so the need to update our food code is really, I think, pronounced in light of how out of date it is, and trying to get Minnesota up into the 21st century and in line with some of the things that have happened at the federal level, so that we're more consistently reflecting food code standards that are accepted practice now. And then also, I think, recognizing that 20 years is a long time to go without updating a food code. I mean, I think that there's an open question is there a way that we can work with our state agencies to have more frequent and regular updates to the food code moving forward once some of this really foundational updates that are needed happen. So in thinking about the food code, it's important to understand how it fits into the general framework of legal authority governing food law. And so this is just kind of an idea of a puzzle of all these different pieces that impact our food law in Minnesota. So there's federal and state statutes, there may be court cases, executive orders, rules and regulations, which the food code is a rule in Minnesota law. And then there are also some non-binding statements of policy and guidance. And I think that we're not going to be going into a lot of detail about some of the other parts of the legal framework for the food code. We're really going to be focusing on the food code as a rule, but it's important to understand that it is not a standalone body of law, that it is part of this other puzzle of other pieces that impact our laws. And then the other thing to keep in mind is that in addition to there being a lot of different moving pieces, I would say, with our food law, there's a hierarchy involved in understanding how the food code fits in with some of those other pieces of the law. And in particular, what I want to focus on here is that the food code is actually exists because it is authorized by Minnesota statutes, and that Minnesota statutes really control what kind of content and things that are included in the food code. And so Minnesota statutes passed by the legislature give the Department of Agriculture and Department of Health specific and directed authority to develop the food code. And then the food code as a rule then provides a lot of meat on the bones of the skeleton of Minnesota statutes. But one of the things I know in working with communities around Minnesota is sometimes people may be frustrated with something that's in the food code, but the frustration may be just because the food code doesn't control that area. It is the statute that controls that area. And Amanda's going to go into that and give some examples, but I think that like food sampling is one of the areas where the food code touches on that, but the food code is actually controlled by some things in statute. And so there is a hierarchy there, and so it's important to keep in mind and ask yourself that question of, is this something that the food code addresses and can affect independent of the statutes, or do you need to go back to the statutes to understand the context? So with that, I'm going to turn it over to Amanda to start talking about more of where we are with the food code revisions and some specific areas of interest.
Thanks, Mary. And I think it's really important that we're having this conversation today because the food code is really a complex set of regulations. The rule revisions and the accompanying sonar that Mary mentioned earlier are over 500 pages long, and there are also numerous references to statutes that need to be considered to fully understand it. And Mary and I have been working pretty diligently to try to get our heads around what these changes mean, and we know there are a lot of you out there who are also wondering about the changes too. But before I dig in, I want to emphasize that because the changes are so complex and numerous, as Mary said, we are really only going to be able to hit on a few highlights today. That said, I do really think this is an important step in getting those in our community who are not large corporations with internal legal or compliance departments a little more acclimated with what's happening so that they can participate in the process if they want to, and so that they really can better start understanding what some of the implications might be with respect to their operations and the communities that they serve. So let's get started with some of that kind of technical information. Just to frame things before we do so, I want to emphasize what the food code applies to and what it does not, at least in terms of generalities. The food code does not apply to all food handlers in Minnesota. Instead, it only applies to most retail food handlers and to food and beverage service operations. So it does not generally apply to things like wholesale manufacturing and other wholesale activities unless the operation also includes retail or food service components. And likewise, it typically does not apply to farming operations. That said, of course, there are caveats to every sort of rule, and again, this is an oversimplification. So this kind of schematic that you're seeing on this slide right here is, of course, missing oftentimes numerous steps that might happen in processing. It's also missing things like transportation. And just want to point out that there are numerous exceptions and exemptions to the general rule that the food code applies to retail handlers and food service operations. And so because there is so much nuance and so much technicality, it is really going to be important for those of you in this space to be working with MDH and MDA to understand whether and how the food code might be applicable to your operation and or if other food safety regulations apply. So with respect to the changes that we're going to be talking about today, we've kind of categorized them in some buckets, and just to go over what those are going to be, we're going to talk a little bit about regulations that touch on personnel, some that touch on equipment, also inspections, labeling and disclosure changes, the general scope of the code itself, and also some general thoughts about readability and language. So digging into some examples of changes that affect staffing, there are a few of them, and one of them includes new rules regarding certified food protection managers. Currently, the rules require most food establishments to have full-time, what's currently called in the rule, certified food managers on staff with some exemptions. But that existing rule that's in place right now would be repealed, and a new rule would be added at 4626.0033. Essentially, the new rule is kind of a makeover of the old rule, but instead of just amending the old rule, the departments decided that they wanted to repeal it and move it from its current spot at the end of the chapter to kind of more right in the meat, the thick of things in the food code. So they've moved it up. So one difference to be aware of, and I've already kind of alluded to that, is that there's sort of a change in vernacular. Under the old rule, the position is called certified food manager, and under the new rule, it's going to be called certified food protection manager, or for purposes of today's slides, I'll probably be referring to CFPM, which is the acronym that's used within the code. Another difference is that under the proposed rule changes, the exemption categories are somewhat different, though it's important to understand that there's still a lot of overlap with the existing exemption categories. And I want to point out that what's been done, there's been some intentionality, as the sonar indicates, in aligning the food or the exemption categories with types of foods and food processing that are associated with low food safety risks in terms of foodborne illness.
And so this is one of those areas where when we think about what a low risk food establishment is, that a lot of times like healthier food, that healthy food, safe food continuum comes into play, where low risk food establishments are usually, establishments serving things like, frozen pizza or packaged, more processed food. And the food code goes into more explanation, and the statement of need and reasonableness, the SONAR also discusses this. But, this is an interesting, because food establishments that are serving healthier food will likely need to have a CFPM because they don't fit into this low-risk food establishment category. While, establishments that only serve low-risk food will be exempted from this. And so that does impact healthier food differently than the safer food categories, as we discussed earlier.
Yep, that's exactly right, Mary. And another thing to keep in mind on the next slide is that there were specific categories of operations that were very specifically carved out as being exempted from that old CFM requirement that will now be required to have a CFPM at each location unless they meet some other exception or exemption. And we've got those listed here. So those of you who are operating in those spaces will want to pay special attention to this change and understand what the implications are for you in terms of staffing requirements. Next. And then finally, with respect to the CFPM rule, there's also some changes to be aware of in terms of the continuing education and certification requirements. Food establishments are going to want to be aware of these to make sure that they don't experience any lapse in their certification that may take them out of compliance with the code. Another example that relates to personnel are proposed revisions to the rule relating to bare hand contact with foods, because these are likely also going to require some additional staff training for at least some organizations. The SONAR says that the departments felt that they needed these revisions to clarify inconsistent standards for employee handling of ready-to-eat foods with bare hands. And there's a few changes to be aware of, and kind of taking them out of order. I don't have the rule up here itself, but if those of you who want to get very technical and dig into it, if you look at Rule 4626.0225, item B of the rule requires food employees to minimize bare hand contact with foods that are not in a ready-to-eat form. And conversely, as opposed to just minimizing contact, item A would clearly prohibit touching ready-to-eat foods with bare hands. However, there are exceptions, for foods that will be combined with other foods and cooked, and there are also exceptions for establishments that are willing to undertake some fairly substantial policy, procedural, and documentation requirements. And so just in light of that, it's probably going to be easier, our hunch is anyway, that it'll be easier for some establishments with set food offerings to create those established protocols and documentation steps. But we're not sure about how this might impact establishments that have changing offerings because they're working with things like donated foods or scratch menus. So just one kind of thing that we've flagged as we've been looking through this.
And this is another area too where when we're thinking about those ready-to-eat foods and how we process foods or prepare foods in a food establishment, this makes me think of salad bars or sandwiches or things where that are featuring perhaps healthier food options are going to have more specific requirements around handling of that food with bare hands, with preparation of the food than what was required before. And so when we're thinking about the healthy food overlay, it does seem like this does have the potential of impacting that. And so it's just as good that you all are aware of that change.
So now let's look at some examples that pertain to changes with respect to equipment. Again, there are others that we could have touched on regarding personnel, staffing, and training requirements. Those were just a few, and now we'll turn to just a few of those affecting equipment. One thing to be aware of is there are changes that both ease requirements and some that likely add additional requirements, at least for some operators. And one example of a change that will be likely easing requirements is a relaxing of the number and types of equipment that must be certified by a national safety accreditation program. The proposed rule, which is going to be 4626.0506, will require only 10 types of equipment to be ANSI certified, which is a reduction in the current number of equipment types that need to be nationally certified.
And this is an area where, based on the work that we've been doing in communities, in smaller food establishments, more kind of local food services, farm to institution types of things, I've often heard of concerns about the cost associated with some of the equipment and these requirements under the previous food code. And so, I'm far from an expert in the costs of this equipment and how that plays out in different business models. But I think it's interesting to note, as Amanda said, that there has been a more focused effort, in an effort to narrow those equipment requirements that have to meet a certain standard, and that others that were covered before are not covered anymore. And so this is an area just to pay attention to, because I know that this has been a concern of people working in communities around feeling that some of the previous food code requirements were very challenging to meet.
Mm-hmm. And I think on that point, Mary, too, it's important to acknowledge, too, that it seems, just from having read through the sonar, that there was a fair amount of intentionality put into that on the part of MDH and MDA. So I think that's great that they were being responsive to some of those concerns and really finding ways to begin looking at where they can ease burdens for smaller operators and hunger relief organizations and the like. So also kind of going back to that theme about different requirements for different types of foods that may or may not be as high risk in terms of their potential for foodborne illness. There are also some exemptions to having those ANSI equipment certification checkoffs for certain types of equipment for certain adult and child care centers, as long as they're serving certain categories of low food safety risk type foods. And then another, I think, good example of a way that equipment requirements are changing in a way that will hopefully be less burdensome for operators is an elimination of the need for manual warewashing in addition to mechanical warewashing, or at least clarification that both are not required. And so by warewashing, we've got it up on the slide here, but we're talking about that sort of cleaning and sanitizing of things like utensils and plates and parts of equipment that would come in contact with food, so like blades on meat cutters and the like. So next slide, yep. So having covered some areas where those requirements are relaxing with respect to equipment requirements, I also just kind of want to point out an example here of one that may at least feel to some as an additional requirement. Here specifically, we're talking about revisions to Rule 4626.0780, and just to kind of back out for a second here, what you're looking at is the actual way that the rule change looks in the proposed rules. And so anything that is not underlined currently exists in the rule. Anything that is got that line through it is being stricken from the rule, and anything that is underlined would be added to the rule. So kind of deciphering all of that, what it means with respect to this rule is that newly licensed and extensively remodeled food establishments and those that add menu items that require washing or thawing of foods in a sink will have to have a dedicated sink for food prep that is not used for hand washing or ware washing or anything else. So without this change, the departments believe that it's not clear that the food prep sink needs to be exclusively used for just that purpose at all times. And it seems from our reading of this rule that existing restaurants may be grandfathered into the requirement of having a dedicated food prep sink unless they add new food products that require washing or thawing in a sink, in which case they would then need to comply with the new food prep sink requirement.
And so this is an area where I know with some of the local food activities and smaller food establishments and maybe some larger food establishments that there are menu changes, you know, the effort to try to serve foods that are seasonally available. And I know that there are efforts to try to be more creative with menus and responding to what supply is there. And so it raises a question as far as the extent to which this requirement with the sinks for those types of operations who are adding or changing their menus could be impacted. And I'm not sure how much detail. I don't think that the food code goes into a lot of detail about what the addition of a food product actually means. And I don't know if the sonar does, Amanda.
Yeah, right. So the food code itself, no, but the sonar does have a comment. I'll just read the quote. It says, if an establishment decided it wants to create a new menu and start using fresh product instead of prepackaged, they will need a way to clean the products, in which case then they're going to need this dedicated sink. So I think that hits on your earlier comment and just sort of reinforces it. Go to the next. And then turning now, I guess, away from equipment and to inspections. Again, we're being sort of judicious in our selection and not able to cover everything, but want to point out that the proposed rule 4626.1787 specifically ties the frequency of inspections to risk levels associated with foodborne illness. And some of this is already based in existing statutory language that the existing rules refer out to. So we're not entirely sure of what the impacts, but we just want to point this out and make sure that it's something that you're aware of so that you can kind of start getting your head around how it might impact you and your operation and the communities that you're serving.
Yeah, so in regard to this, it does seem like there's a framework that Minnesota food law, both statutory and rule under the food code, uses to approach the risk of foodborne illness. Not healthy food, not nutritious food, but the foodborne illness piece that's really the focus of the statutes and rules at this stage. And it is based on this assessment of risk for different types of food. And I think that from a foodborne illness perspective, that makes sense. I mean, there are some foods that we know are more likely to lead to illness than others in the immediate sense, not the chronic health issues. And so this risk-based assessment and inspection framework is something that has existed before, but I think is more clearly called out in the food code. And I think is kind of at the heart of some of that conversation or the continuum between healthy food and safe food. That risk-based assessment, I think, is another way to think about that continuum.
Right. Okay, and then now turning to labeling disclosures, just want to hit on a couple highlights again. One is that the packaged food label requirement standards have been updated just to bring them more in line with federal requirements, and you can find those at Rule 4626.0435. It's not a new rule, it's just revisions to the existing rule. And then There are also some new disclosure requirements that will require identification of foods with high risks associated with them, because they've got things like undercooked meats or shellfish or raw eggs and the like. And in that case, there are some requirements with respect to how that needs to be conveyed to the consumer by way of brochures or menus or table tents or similar communication methods. And then also we want to just kind of, zoom back out and talk a little bit about the scope. We talked about that a little bit, or I talked about that a little bit at the beginning, but we want to kind of acknowledge that there are some changes to the definition of what a food establishment is, and that's important to understand because it defines who is and is not affected by the food code. And so, again, we're looking at what the actual change language is. So again, anything that is not underlined is currently in the rule. Anything that's got a line through it is being stricken from the rule, and anything that's underlined is being added. And as you can see, looking kind of in that Part A of Subpart 35, which is the definition of food establishment, there were several types of establishments that were called out as examples of the types of operations that the term was meant to apply to. And those are being stricken out to make the definition a little more broad and presumably more flexible. Likewise, turning to B, there were some types of operations that were specifically called out as not falling into that definition. And those are being deleted, but we just want to emphasize that we've read the sonar, and it specifically indicates in the sonar that the food code is not intended to apply to wholesale or manufacturing operations. Again, with caveats, and one of those caveats would be for those types of operations that are located inside retail operations. So the focus continues to be on retail operations and food and beverage service operations. But acknowledging that that's not expressly stated in the proposed rules, it may be something that you want to just get some extra clarity on from MDA and or MDH, depending on who you're working with. And next slide. And also, we want to point out that there do continue to be specific exemptions called out in the rule that remain. And these are largely, or in fact, I think exclusively statutory exceptions that are sort of reiterated in the rules themselves. And kind of alluding to what Mary said earlier, these aren't things that the food code can sort of change. They exist in statute, but they are referenced. But we want to point out that there may still be some lack of clarity around what some of these exceptions mean. And I'm just going to call out a few of them. We've got some of them listed up here, and there are additional ones, but 3 to hone in on are the exception for food sampling and demonstration at farmers markets or community events, and Mary talked about that a little bit earlier. But the confusion that we've heard around that is that the term farmers market is defined by statute, but community event is not. And so there have been questions that we've heard as to what types of activities apply or would fall into that definition of community event, and just kind of challenges around figuring out if food sampling, for example, at food shelves or the like could qualify as a community event. Did you want to add to that?
Yeah, and I think that what we're trying to point out here is that because this food sampling and demonstration at farmers markets and community events is addressed in statute, the food code can't change that because there is a statutory base for that exemption. And so while there is confusion about that, and I think that there's a lot of conversations going on right now in trying to make sense of, what a community event might be, and this, I think that the food sampling at food shelves is a perfect example. The food code only has the authority to implement the statute, and it can't go beyond the 4 corners of the statute. So those kinds of questions the food code may not be in a position to clarify that because the statute is on its face what it is, and the food code and MDA and MDH can't necessarily go beyond what the statute says.
Mm-hmm. And then, right, and in addition, that there's a cottage foods exemption that also uses that language, that community event language, which also is not defined for purposes of that exemption either. So there's another place where, again, there might be some confusion that relates to the statutes, but it was not something that could really be addressed in the food code itself. And then thirdly, the other example, just to kind of call out, is the potluck exemption. Again, the term potluck is not defined in the statute. And so just kind of understanding how inclusive or exclusive that term might be remains probably somewhat of an open question, and something to kind of negotiate and navigate with your the people you're working with at MDA and or MDH. And zooming out from those kind of really technical points that were just highlighted, you know, I guess one thing that strikes me, has always struck me reading the food code, is just you know, some questions, and I don't think I'm alone, which is kind of just about how easy the code is to navigate for those that don't have a food science or a legal background, and how easy it might be to navigate for those who don't speak English or don't speak English as a first language. You know, we know that there are no official translations of the code. You know, we also understand too that, you know, it's a law, and there are lots of technical components to food safety, and so some of that is probably unavoidable. But we also want to acknowledge the kind of broader community conversations that are happening with respect to figuring out how the food code can be made more accessible to the larger community, and especially for smaller operators that, again, don't have those internal compliance departments or resources to rely on legal staff.
And so this really does bring up, you know, this question about equity, which is definitely at play with Minnesota's food law and access to resources. Amanda talked about, you know, some of these things, from, you know, just understanding the complexity of some of the requirements to comfortability with English as a language, especially in very complex and confusing areas, and also food establishments that may be more like of a family operation, have limited staffing and limited resources to be able to access and navigate some of these changes. And so I just wanted to acknowledge that there are some equity implications here. And I know from conversations that I've had with people in the community and MDA and MDH that there is, you know, people are concerned about that, and it is not a straight path. I think that one of the things I've been thinking about with these food code revisions is there's progress and not perfection. And, you know, there's progress in a lot of ways, and it is a work in progress. And trying to grapple with the complexities, not just of the specific details of the food code, but then how do you translate that into the community and make it accessible is a work in progress. And I think that the conversations happening in the community and with state agencies can really help to elevate and, you know, find creative solutions within the constraints of a legal structure that, you know, as an attorney, I can say it is not designed for that easy applicability and understandability. Is not, the law isn't always designed with that in mind.
This is not your bedside reading, Mary?
And this is not my bedside reading. Yes. So with that, I just wanted to, one of the things too that can be intimidating by some of this legal rulemaking and this legal process is just like, how does it actually work? And just understanding the process can be a barrier in and of itself. So I just wanted to spend a little bit of time. I'm going to go through these slides pretty quickly, but just to help you understand where things are in the process and, you know, and just kind of looking into the future. So this is just a snapshot as we understand it, and where the current food code revision process lives. And I just want to acknowledge that this process of review and revision of the food code has been going on for years. And I've heard various different, you know, anecdotal stories about, how involved and it is in all of the blood, sweat, and tears at the agency level in getting things to this point. And so I think that it's really great that we are at this point, and it's progress, not perfection, right? And so the notice of hearing was released this past November, and then Thursday and Friday there are actually public hearings where if you're interested in getting more information about any of these areas that we've touched on or other areas that you may have an interest or concern in, there are public hearings Thursday and Friday available. You can go in person, and there are also video conferences available around the state. We've just included this link here because there's a lot of different locations around the state with video conferences, and we're in a position to kind of go over that detail, but just to alert you to this opportunity to learn more. And then currently, the end of the comment period is scheduled to be January 22nd at 4:30 p.m. Now, after the hearings that end Friday, there's a possibility that some of these dates may change, but that is really up to the administrative law judge to make a determination about that. So the dates that we have going into the end of January and onwards are anticipated based on what we know currently.
Yeah, I think it's fair to say that the 4:30 p.m. on January 22nd will likely be a very firm date, and there is probably more wiggle room in that rebuttal period. So I think we should all just assume that the 4:30 on January 22nd is what it is, but certainly the rebuttal period has more, the judge has some discretion in extending that by a bit, not a lot.
Okay. And what is a rebuttal period? So a rebuttal period is basically an opportunity for people to respond to comments or issues that may have been raised during the comment period. So it's not, you can talk about anything under the food code revision during the rebuttal period, but it's a narrower focus in case some additional issue came up during the comment period that you're interested in or may have questions about. It gives you an opportunity to respond to that narrower universe of information that came in during the comment period. Then once the rebuttal period is over, the administrative law judge will issue a report, and then the agency's Department of Agriculture and Health will have an opportunity to review the report from the ALJ, any recommendations that the judge may have made, and make revisions to the rules, and then the rule will be finalized. And there are some kind of legal stepping stones, it's 5 days after the ALJ report is reviewed that MDA and MDH are required to take at least 5 days before making any final decisions. But those things I think are still in flux, and that we can just look to the Departments of Agriculture and Health for their planned schedule going forward. So I'm going to quickly just go through some slides here in case you're interested in learning more about the hearings or the comment period. We're just going to make, these slides will be available if you want to find out how to go online and work with this interactive online process. So there's just several slides here on how to submit a comment, how to work with the sign-up process, logging in, and then just finding the discussion thread for any comments on this specific rulemaking. I mean, there are different rulemakings that are going on in a lot of different areas of Minnesota, and so it's important that you're paying attention to the Minnesota Departments of Agriculture and Health notice of hearing discussion specifically on the food code as indicated on this slide. And then if there are specific topics that you're interested in, you can review those topics based on, you can see other comments that have been submitted. And also this is good for you to know that if you submit a comment that it will be available, other people will be able to see it, and it's public record. And then you can provide comments if there's something that you want to raise or an issue that you think is important for the Departments of Agriculture and Health to consider. And you can also attach some documents to support or to provide additional information for the agencies. So with that, the hearings are scheduled for Thursday and Friday, and this is the general agenda. It will be
I just noticed a date issue. It's the 11th and the 12th.
Oh dear. Okay, so it is January 11th and 12th. Apologies for that. Thursday and Friday of this week. The agenda is going to be, this is the agenda that's publicly available. The administrative law judge is going to be overseeing this, and it is a somewhat official process, but it is there for public participation and to create transparency and sharing of information between state agencies and the citizens of Minnesota who are impacted by these changes. And there's a link for more information about the hearings.
Yeah, and we just want to kind of give everyone a chance to understand from a kind of basic level what the hearing procedure might be like. We understand that showing up to hearings like this can feel intimidating, especially for those that aren't used to participating in formal legal processes like these. And again, just to kind of level that playing field and make participation as equitable as possible and accessible as possible, just want to give you a little bit of understanding. So fairly straightforward. You're going to sign in. You're going to go and state and spell your name, address, and then also indicate any interest or other group that you represent. And then you're going to provide your questions and comments about the rules that you want to address or rule. And you're going to want to be specific in identifying which rule or part of a rule that you're talking about. And to the extent that you're trying to make a comment about the rules themselves in general, I think it's fairly safe to say that you could say that too, but be clear in identifying that that's what you're doing. And then be aware that there can be some give and take, some Q&A back and forth. And so after you've stated your question or your comment, there may be a bit of discussion, and also be aware that there might be time restrictions. The judge will likely give direction with respect to how much time she wants to allot to each person who wishes to testify, but just be aware that you may not have an unlimited amount of time up there. And finally, the information we've gotten from the administrative judge is that it's welcome, I think probably even encouraged, that if there are written comments that kind of reiterate what you're going to testify about, that you can leave those as an exhibit. And I think that might be helpful.
And I just want to state again that our dates are wrong. It is January 11th at 12. Apologies about that clerical error on our part. So we're wrapping up right now, and I know that we had scheduled this this webinar to go until 1 o'clock. We can go a little bit after that if there are questions. But before we get to questions, I just wanted to alert you to some additional resources that you can access about the rule revision process and the next steps from the Department of Health. So on the left there is that link that I find to be very, very helpful. And then there's also this 20 questions, proposed major changes of concern to the Minnesota Food Code that the agencies released several months ago that provide some more accessible language about some of the food code revisions. And so I think that those are really great resources. I have found them very helpful. And then before we turn to questions, I think that one of the conversations I've heard in the community is so the food code is being revised, and then what? And I think that's a fair question. And I'm hoping that we as a community and are learning that the pace of rule revisions can be excruciatingly slow. I mean, it takes a lot of time and administrative energy. And so since 1998, right, we haven't had the food code revised. And now we are entering into a new era, which I think that's great. We're entering into the 21st century, but then is there a way that we can learn from the past experience of maybe 20 years is too long to wait to update the food code? And as I understand it, the agencies and other community advocates are having some conversations about how can we move forward after the current revisions are finalized, so that we can more quickly and respond to things in the community and hopefully engage more fully with this tension between the healthy food, safe food continuum and work in partnership with the agencies to have our food code be more of a living type of a document that responds as we are moving to address some of these chronic long-term health issues that are a result of relying too much perhaps on low-risk foods in our diets. And so I just wanted to just acknowledge that there are some opportunities, and that there's been a lot of work preceding or in conjunction with some of the food code revision work, trying to grapple with that. And so I'm just pointing out a couple of resources here from the Minnesota Food Charter, this Healthy Food, Safe Food Action Guide that discusses some of the food code opportunities possibly in the food code to bring together the healthy food and safe food conversation more into the Minnesota food law. And then also this work at Extension that also discusses some of these issues more fully and thinking of public health from that chronic, longer term health impact from the food that we consume. So with that, I think that we have just a couple of minutes, and I understand that there are a couple of questions. And so I'm going to turn to these questions right now and give you all, those of you who are still on the line, a chance to submit some other questions if you have them. So one of the questions from viewers is, does commenting on rule changes count as lobbying?
I think there's a lot of nuance to the answer to that question, and we are certainly not experts in lobbying regulations. We have tried to carefully navigate around them to the extent that they apply to our organization for purposes of this webinar, but it is certainly something that you all will want to be cognizant of to the extent that your organization has restrictions on lobbying. I don't know, Mary, if you've got other thoughts about that.
No, I think that this is really something as far as you working within the constraints of your organization, because different organizations, even different nonprofit organizations, have different parameters around lobbying. I know that I have in previous worked at a nonprofit where there was a certain limited amount of lobbying that was allowed. And so I don't think that we can answer that for your specific situation, but I think that it can be considered lobbying in certain situations. And so that is a really good question to ask. Then another question is, will food shelves be allowed to do food sampling now? And I think that the answer to this is that the current food code revisions do not change anything with food sampling for food shelves. However, I think that there is an open question, and Amanda alluded to this, and it goes back to the statute as to whether or not food sampling at a food shelf would be considered a community event similar to the sampling at farmers markets that is allowed. And we don't have an answer for that because there isn't direction in the statute about what a community event is. And so, like we were saying, that the food code cannot do more than the statute allows. And so absent any direction from the statute about what a community event is, the food code has not provided any additional indication about that definition.
Yeah, and I would also add the other way that you might be able to sort of suss out what that means is if there had been any case law that had addressed that. So a judge sort of taking statute and trying to apply it to a real scenario, but there hasn't been any that we've seen. So there's really just sort of a void there. Yeah, we're sort of in the same place that you all are with trying to understand what exactly that term means.
All right, I'm going to check and see if we have any other questions. I think that we don't. And so I just want to thank you all for joining us on this journey of food safety and trying to understand some of these new changes in the food code on the horizon. And I know that we here at the Public Health Law Center have been having some conversations with the Departments of Agriculture and Health about the possibility of doing another webinar or providing some more information once the food code revisions are finalized to really start talking about next steps and also helping to identify areas where there may be needed some additional attention moving forward. So thanks so much, and we look forward to hearing from you and talking to you soon.